Welcome back to Organized, the business law breakdown. I'm your host, Seth C. Oranburg, and today we're unraveling the tricky world of contract interpretation. When words don't mean the same thing to both parties, or when, after the fact, it's convenient to discover alternative meanings, how do courts step in to figure out what the contract really means? Imagine this. You order chicken from a supplier, but when the shipment arrives, it's not the tender young birds you were expecting. It's older, stewing hens. Who's right? Is chicken just chicken, or is there more to it? Today, we're talking about how courts interpret words in contracts, using real-life examples where the meaning of a single word could make or break the deal. In our last episode, we explored fraud and misrepresentation, situations where one party might have been intentionally misled. But today, we're focused on cases where parties are honest, but simply interpret the words in their contract differently. We'll dive into the famous case of Frugaliment Importing Company versus B&S International Sales Corp., which I'll refer to as the chicken case, where Judge Friendly, ready for the court, had to decide what the word chicken really means in a contract. Yes, that's a real case. We'll also look at the tools courts use to figure out the meaning of words, such as trade usage and course of performance. So if you've ever wondered how a single word in a contract could lead to a courtroom battle, stick around. We're about to explore how courts interpret words in context and make sense of agreements that aren't as clear as it may initially seem. Now that we've set the stage, let's break down the tools courts use to interpret contracts. It's not always about taking words at face value. Context matters. And even at face value, something that appears unambiguous can actually have latent, different meanings. When disputes arise over the meaning of a contract, courts look beyond the literal text because they need to figure out what the parties really meant. The first step is often applying the plain meaning rule. If the contract language is clear and unambiguous, courts interpret the words according to their ordinary, everyday meaning. But what happens if there's special meaning, like in the use of trade? For example, did you know that a 2x4 is not actually 2 inches by 4 inches? If you're a carpenter, you surely do. And if you're Home Depot and a carpenter in a contractual relationship, you know what 2x4 means. It's not the ordinary meaning of 2 inches by 4 inches. Or what if language is open to multiple interpretations, like the word cleave, which can mean either to separate or to stick to? Courts have to determine when the contract is ambiguous, and then they need to resolve that ambiguity in order to enforce the promises people made. One key tool is trade usage, especially where we're dealing with commercial contracts. Courts look to how certain terms are used in industry, at least when the parties are in that industry. For example, what does the term chicken mean in the poultry industry? Does it refer to any bird from the genus classified as chicken? Or does it mean something more specific, like only young, tender birds? What is the meaning of a term? It depends on industry norms, and courts will look at trade usage to resolve disputes. Courts also care about how the parties behaved under a contract, which is known as the course of performance. If parties acted in a certain way that shows how they understood the terms, their behavior should inform how the contract is interpreted in other cases. Similarly, if the parties have done business together, their past dealings, also called the course of dealing, may help explain what they mean under the current agreement. Let's break it down with a famous case, the chicken case, the only case that will get Professor Oranburg to dress up in a chicken suit in public. This is a famous case that illustrates the principles of contract interpretation, and its name is Frugaliment Importing Company versus B&S International Sales Corporation. And yes, the dispute was over the word chicken. One party expected the delivery of young broilers, and the other supplied older stewing hens. The court had to figure out what chicken meant in the context of the contract, using course of performance, course of dealing, trade usage, and other terms to figure out what this really meant. The case is a great example of how a single word can have multiple meanings depending on who you ask. The court has to step in and figure out whose meaning applies. In this 1960s case, Frugaliment, a Swiss company, entered into a contract to buy chicken, quote unquote, from B&S International Sales Corporation. But when the shipment arrived, the buyer, Frugaliment, wasn't happy. They expected young, tender broiler chickens suitable for grilling, but instead they received older, tougher stewing hens made for soup or for animal feed. Both parties believed they were selling and buying chicken, but they had very different ideas of what this meant. Frugaliment argued the term chicken should be interpreted to mean only young broilers, while B&S claimed the word chicken applied to any bird classified as chicken, including, of course, the stewing hens they delivered. And Judge Friendly, writing for the court, had to decide, what does chicken mean in this context? The court examined several factors, including the trade usage in the poultry industry and the communications between the parties leading up to the contract. Frugaliment argued that the industry standard in international poultry sales was to use chicken to mean young broilers, and they brought experts in that purported to make this point, while B&S pointed to dictionaries and other broader definitions that included stewing hens, and again brought experts to prove their point. Ultimately, the court ruled in favor of B&S, finding that Frugaliment hadn't met their burden of proving chicken was meant as they intended in their contract. The broader definition stood. So Frugaliment shows us that courts don't just look at words in isolation, they consider the context, including the trade usage and the parties' actions, to interpret what the contract really means. They may have to actually take evidence, testimonial evidence, from industry experts in order to arrive at this meaning. In this case, because the broader definition of chicken was reasonable and supported by evidence, the court upheld the seller's interpretation. So Frugaliment teaches us what seems like a simple word can have a lot of complexity, depending on the context. But what if the contract had been even more ambiguous? Let's discuss a what-if scenario to explore how courts handle unclear language. Imagine you enter into a contract to buy fruit, but the delivery includes only apples and oranges. You're expecting a wider variety, including grapes, bananas, and melons. Can you claim the contract was breached and the word fruit wasn't specific enough? It depends. Courts would look at the context of the contract to decide what fruit means. While surely apples and oranges are types of fruit, we might ask if there's any trade or industry standard that defined fruit as including a specific variety of produce. The court would take that into account if both parties were involved in the trade of fruit. On the other hand, if the term fruit was used broadly and there is no discussion or agreement on what specific types were included, the court might side with the seller as they delivered a product that technically fits the definition of fruit. And while we're on this, I'll give you a little historical anecdote to help you remember this ambiguity. Have you ever wondered why a pineapple is called a pineapple? A pineapple and an apple seem pretty different, so why is it seem like a pineapple is a specific type of apple? Well, the answer is that in European history, the word or the proto-word for apple was generic and was used to mean all kinds of fruit. And we see this in some of our depictions of a biblical event. And the Garden of Eden story, where Adam and Eve ate the forbidden fruit, we often see the fruit depicted as an apple. And that's partly because the word for fruit and the word for apple were the same at that time in history. Now, it doesn't mean that what they ate was an apple. What they ate was indeed a fruit, a more general term for fruit. But we can see the remnants of this ambiguity that has persisted throughout time in words like pineapple, which are a pine type of fruit, if you understand the etymology of it. It's just an example of how words don't always have a clear meaning, and these confusions can result in historical problems and confusion, like the example of an apple being used to signify the fruit of the tree of knowledge because the words used to be synonymous and more generic. Let's turn up the what if one further notch. What if the contract specified that fruit must come from a specific region known for apples? For example, if you offered fruit from New England, you wouldn't expect to be receiving oranges. Would you expect a wider selection if you order fruit from a producer in New England? Yes, that could change things. The mention of the specific region might signal that the parties intended fruit to mean produce commonly grown in that area. If apples are primarily grown in New England and oranges are not, the court might interpret the contract to require one and not the other, especially if the parties didn't explicitly ask for other varieties. This is where trade usage and context becomes important in clarifying ambiguous terms. Finally, let's explore a situation where both parties had different interpretations of the word fruit, but one party had significantly more knowledge of the industry. If you're just an ordinary consumer that places a mail order fruit basket on Amazon, and the seller is a long-term industry participant in the fruit industry, does this imbalance of knowledge impact how courts interpret the contract? It absolutely does. As a basic consumer, you don't necessarily have industry knowledge. The trade usage of the term fruit is probably inapplicable to understand your meaning because you're not part of that trade. So when interpreting vague terms like fruit or chicken, courts look at context, trade usage, if both parties are in the trade, and sometimes the balance of power between the parties when deciding which meaning prevails. Clear communication and understanding of the terms can prevent disputes like this from arising. Now that we've explored some scenarios, let's move on to the world of pop culture to see how ambiguous terms and contract disputes show up in everyday stories. Let's step into a classic example from the show Seinfeld. In one episode, Elaine orders a quote-unquote big salad from a diner, only to find that George takes credit for buying it. The entire episode hinges on what big salad means to each character. One says it means extra toppings. Another says it means a larger portion. The confusion over this seemingly simple phrase leads to a comedic argument over who deserves credit for the concept of big salad. While the stakes in Seinfeld are comically low, this type of misunderstanding can lead to a bigger issue in contracts. Just like the term big salad can mean different things to different people, words like chicken or fruit in contracts can lead to disputes if they're not clearly defined. Even a word that seems clear, like apples, can have ambiguous meaning. There are, in fact, many varieties of apples, and they cost different amounts. A Red Delicious may be a fourth the price of a Honeycrisp. So if you don't specify which type of apple you're looking for or which type of fruit you're looking for, you may be at the mercy of the lowest common denominator when receiving whatever the seller ships. Another pop culture moment involving ambiguous terms involves The Simpsons, where Homer signs a contract without reading it, something none of us ever do, I'm sure. Homer later finds out that the contract's vague wording allows the company to fire him at will. The humor comes from Homer's lack of attention to details, but the lesson is clear. Ambiguous or vague terms in contracts leave parties vulnerable to unexpected outcomes. From Seinfeld to The Simpsons, pop culture often represents the importance of clear communication and precise wording. A miscommunication can result in a hilarious episode, but it can also lead to a disastrous contract litigation and other unexpected consequences. Let's wrap up today's episode with a quick recap of key takeaways. We explored how courts interpret contracts when the meaning of a word is not as clear as it seems. In our Break It Down segment, we discussed regalement, where the term chicken has two different interpretations. The court decided that the broader definition applied because the buyer hadn't proven the word was limited. We also looked at tools courts use to resolve ambiguity, such as trade usage, course of performance, and course of dealing. And through our what-if scenarios, we saw how courts handle vague terms like fruit by considering context, industry standards, and knowledge imbalance between the parties. The key takeaway is that contract interpretation is about much more than reading words on a page. Courts will dig into the context and the agreement, the industry norms, and look at how parties behaved under that contract to figure out what their words really means. A simple term like chicken can carry different meanings depending on the situation, and it's up to courts to resolve these disputes. Have you ever entered into a contract where the terms weren't as clear as you initially thought? Have you ever had a deal that went bad because it turned out the parties did not use the same word in the same way? How did it turn out? I'd love to hear your stories or any questions you have about contract interpretation. Share them with me, and you might hear your story in a future episode. That's all for today's episode. I'm Seth C. Oranburg, and I thank you for exploring contract interpretation with me today. I hope you found the lesson insightful and practical. Remember, until next time, keep your agreement strong and your argument stronger.